I don't see Amanda Taylor anymore. Did you all come to an agreement? Oh, there she goes.
Hey, Judge. Yeah, I'm here, Ms. Taylor. We do have a consent judgment.
Oh, okay, I think she's logging back in now.
Oh, okay.
Some reason it didn't let me do it.
Okay, sounds good. We're on the record in the matter of Huron Development LLC versus Amanda Taylor in file number 22-03508. LT counsel appearance.
Joe Joseph for the plaintiff.
Okay, and Ms. Taylor is present via Zoom without counsel, is that correct?
Yes, ma'am.
Okay, ma'am, today's the date and the time that was set for a hearing for non-payment of rent. My understanding is that you and Mr. Joseph have come to an agreement. That's accurate, ma'am?
Yes, ma'am.
Okay, Mr. Joseph, please place the terms on the record.
Thank you, Judge. We've come to a consent judgment for possession only. Total rent to retain is $5,040.02 plus court costs of $166.56 for a total judgment of $5,206.58 with a writ to issue after the 13th if it is not paid and defendant is still residing in the unit. Ms. Taylor has consented to me signing her name to this judgment. She's also been given her rights under 4.201, specifically regarding the 3-day rescission rule. And we're just asking the court to adopt this as set forth here.
Okay, that's correct, Ms. Taylor.
Yes, it is.
Okay, you understand that you have the right in this matter to be represented by counsel,
Yes, I do.
and you've appeared today without counsel, correct?
Correct, I did not.
So you're waiving your right to counsel today?
Yes, I don't need anybody.
Okay, very good. And then you also have the right in this matter to proceed to a hearing, or you could have demanded to have a jury trial in this matter.
No, I'll
You're
have
waiving
it
your
paid
right to
for.
trial at, okay, and you do not want to proceed with a hearing, correct?
Correct, I do not.
Anybody threatening you or promising you anything to get you to waive those rights today?
No, ma'am.
Okay, you have 3 business days, ma'am. If you leave here today and determine that you misunderstood the rights that you just waived, you can request to have this judgment set aside. The court will then set this for a hearing. You will articulate to us why it was that you, or how it was that you misunderstood your rights, okay?
All right.
Do you have any questions?
No, ma'am.
Okay, and you've given Mr. Joseph permission to sign this agreement on your behalf?
I have.
Okay. Any additional matters for the record today, Mr. Joseph?
Nothing further on this case, Judge. Thank you.
Thank you. You're all set, Ms. Taylor.
Thank you.
Thank you.
Judge, I do see, I believe Mr. Rainier is here on one of my cases. If we can get a breakout room, that would be great.
Okay, and Mr. Rainier, you do not have an attorney, correct?
That is correct, Your Honor.
Okay. What's our line? Okay, Tony?
Yes.
From the record in the matter of Michigan Estate Housing versus Elsa Honig, file number 22-03504 LT. Appearance for the record, counsel.
Gregory R. McKay on behalf of the plaintiff, P62030.
Thank you, and ma'am, Ms. Honig, you're here without counsel, correct?
Correct.
Okay, we adjourned this matter that was set for hearing because you needed to get in contact with my half.
Yes,
Were you able to make contact?
yes,
And
yes.
what did you find out?
I did talk to them. I actually just got phone again right before I walked in the door. They did submit the funds and they were sent back they submitted them to Loan Care, which is my mortgage holder, or who I pay my mortgage payments to, and it was sent back. They're not sure why it got sent back because there's no notes on my file from Loan Care, and I did talk to Loan Care myself. And it just said that they denied the funds because of my house. I believe because of the sheriff's sale. Is that, I'm not quite following the sheriff's sale sold date thing.
I'm not sure. I missed
Yeah, or when it even happened. They didn't have a date for me. And I told him I literally was walking into court today and, he said, call him back because he'd like to investigate more, but aside from that, I was able to speak with, the attorney that I had the consultation with, and she listed a bunch of things that I possibly could, I guess, apply for to avoid losing my house, whether it be bankruptcy or loss mitigation or anything like that. So I don't know if that's something I talked with him about.
Okay, you have your device, you can log on to Zoom.
I don't have Zoom downloaded, but yeah,
Okay, can you download Zoom? We'll get you in a private meeting room with them. You can discuss those things with them
Okay.
privately, okay?
yeah.
Thank you. We're off the record.
Oh, great.
It's the same channel, so you have to enable that phone stuff. You know, do. Probably not put yourself on mute for step your screen,
My screen.
but
Mr. McKay, you should be in room 1. Okay, we're on the record in the matter of Huron Development LLC versus Joseph Renier, file number 22-03509 LT, counsel appearance.
Thank you, Judge Joe Joseph and the plaintiff.
Okay, and Joseph Renier is present without counsel, correct?
That is correct, Your Honor.
Okay. A date set for a hearing for non-payment of rent. Mr. Joseph, did you all come to an agreement?
We do. We have a consent judgment for possession only. Gives Mr. Renier until the 20th to get the amount paid or to vacate. The amount that is in arrearage is $4,708 plus cost of $166.56 for a total amount of $4,874.56. And again, that gives him until the 20th to get that paid. I've gone over his rights under 4.201 regarding the 3-day rescission rule, and he has consented to have me sign his name to this judgment for entry.
Okay, Mr. Renier, you understand the terms and conditions of the consent judgment?
Yes, I do, Your Honor.
Okay, and you're willing to waive your right to be represented by counsel in order to enter into this agreement today?
Yes, Your Honor, I waive that right.
And you're also waiving your right to have a trial. You could have had a trial by jury. You want to waive that?
Yes, Your Honor, I waive that as well.
Anybody threatening you or promising you anything to get you to waive your rights and enter into judgment today?
No, ma'am.
Okay. You have 3 business days from the time that you leave here to return to the court and request to have this judgment set aside. If you leave here and determine that you misunderstood the rights that you waived in order to enter into this agreement. We'll then set this matter for a hearing, okay, sir?
Okay.
The writ date was the 20th, you said?
Yes, Judge.
Okay. Do you have any questions today, Mr. Renier?
Oh, no, I don't, Your Honor. Thank you.
Any additional matters for the record? Lastly, Mr. Renier, did you give Mr. Joseph a permission to sign the consent judgment on your behalf?
Yes, I did.
Okay, very good. Any additional matters for the record, counsel?
Nothing on this case, Judge.
Okay, you're all set, Mr. Renier.
Thank you, Your Honor. Have a good day.
Same to you. Do we know what happened to, the attorney that was supposed to be here for Herman? Not Herman, oh no, that's Jacob, that's the state, okay. No one showed up here? Okay. Okay, no one appeared for Murray Pugh. You can submit default on that one.
Okay.
I'm assuming that Ms. Koenig is all set in breakout room.
I think the only other case I have, Judge, is not up until 2:30. Miss Martin's case, if that's still on your docket, was adjourned by stipulation.
I haven't received a stipulation to adjourn.
Yeah, it was kind of a 11th hour one yesterday, so I'm not sure if it's gotten to the court yet, but with opposing counsel, there was a stipulated agreement to adjourn the case. I believe someone from Mr. Herman's office must have reached out to the court because we got a time for 2:45 on March 15th.
Yeah, for Martin. Who adjourned it? Sarah sent us that. Someone who puts the date on the bottom. Okay, that one's all set.
Thank you.
Sarah is on that case. Did she send a appearance? I think it's still, well, we don't have any one name from else. Teresa Martin. It's on mine. doesn't have a defense attorney on there. Okay, Ms. Honig, are you all set? Okay, you can come back up to the table. We're back on the record. In the matter of Michigan State Housing Development versus Elsa Honig. Ms. Honig, you and Mr. McKay had an opportunity to speak privately. I'm not sure if you all came to any proposed resolution. I'll let Mr. McKay advise.
Yeah, there's nothing, I mean, it's already been 3 adjournment, or this is the 3rd hearing on this eviction action. I don't know what I can't offer, she wants to keep the house and it's past the redemption period and there's nothing I can advise. I can't advise her or negotiate on that basis. I can only give people more time to move. If I can do anything.
Okay. So you can only give her more time to move, and what is the amount of time that was offered?
Well, if we didn't get into that, but I can give damn it. Let's see, it's the first. I can give till the 22nd.
Of March is what he's saying. And this is a land contract.
No. It's a mortgage. It's a mortgage foreclosure.
Mortgage foreclosure. Was there already, you said there was a sheriff's sale already set?
Yeah, sheriff's sale took place in February.
Okay. Gotcha. Okay, man, well, you have a couple of options, and he's offering to negotiate the writ date being the 22nd of March. That's more than what the statute requires him to get here. You do understand that, correct? Okay, if you want to talk to him privately about trying to get additional time, that's a private discussion you need to have. The court.
He already told me he won't work with me, so.
Oh, well, you're
That's
talking
not,
about
no, that's not what I said. I said I can't work with her on buying back the property.
If you want to talk to him privately about negotiating more time to vacate, that's something you need to do off the record. He's not in a position, as he stated here and on the record, and obviously to you in private, that he can't negotiate the buyback of the property. That's not right. He can only negotiate what we're here for today, which is a termination to vacate the property. And so that, if you want to talk to him privately about more time, I'll give you an opportunity to do that. Otherwise, unless you have a reason why we need to proceed with the hearing and for you to establish before the court why you can lawfully withhold this property, it's up to you if you want to enter into agreement or if you want to have a hearing, but it doesn't sound like you're disputing that you owe this money.
No, I was telling him that my money was not something I was trying to get in order to buy back my house. I was being proactive way before this all started in order to get caught back up on my payments. I lost my job during COVID because of COVID, and I've been trying to get caught back up. So I was already trying to beat the band on not this happening.
Okay.
And it didn't happen because when I applied for my app and the sheriff's sale was happening, they crossed, and even my app sees that on their end now. That's why he wants me to call him back. I don't know why he wants me to call him back, because there's nothing he can be able to do for me. That money's no good to me now. Consultation with my lawyer, she gave me a list of things, possibly that I could do in order to not lose my health. And that's right, said Mr. McKay, I know he's not here to advise me, he's not my lawyer. I'm not asking for his help in that way. But there's other things I want to be able to try, other avenues I want to explore. And if need be, and I have to go ahead and hire a lawyer, then I will finally just bite the bullet and do that, because I can't do this. I don't know half of this stuff and what it all means, and I'm about ready to just have a full-blown panic attack.
Okay, well, don't have a panic attack.
I'm
You
trying
can't-
not to.
It's not gonna make the issue
I
go
know,
away. You have
I
to,
know.
you have to try to remain calm. I
I know,
recognize
already-
these are serious circumstances.
I know
This is
it
your
is.
livelihood here, ma'am, but having a panic attack is not gonna get
I
this
know.
issue resolved.
I took medication for it, I'm just saying.
Oh, I
my
get it. I
anxiety
want you to
is-
stay, I want you to stay
It's
as
hard.
calm as you possibly can. It sounds like you did get some legal counsel prior to coming here.
I did.
And I don't know what they advised you. All I know is that today is the day set for your hearing. The plaintiff's not in a position to negotiate anything other than extending the writ date. And so you need to take some time and think about that. Do you want to enter into a consent judgment with them with an extension of the writ date? Or are you seeking to move forward with the hearing? And if that's the case, today is the date for that, and you would need to have some information, some evidence to provide to the court. So if you need to take some time to think about how you want to proceed today, you can do that. I recognize you need to calm down so that you can think clearly.
Okay, so one more time, what are my options?
Typically, you would meet with the plaintiff's attorney, and you all can negotiate what's called a consent judgment, or conditional dismissal if that's what they want to do. But that would negotiate the time frame and the conditions upon which you would vacate the property. And that typically happens when the tenant is not disputing that they owe the money, which is a situation where you've already indicated you don't dispute that.
Right.
So you can do that. It sounds like that Mr. McKay has already offered to give you a writ date of the 22nd. You can go and speak to him in private if you think you can convince or negotiate beyond that. And then again, you're the one with the list of things that you've talked to an attorney about. I don't know what your plans are with that, but take some time to think about that so that we can know how we're moving forward before you waive any of your rights.
Okay.
Did you want to go back and talk to Mr. McKay again?
I don't think that's gonna do me any good.
Okay. So are you gonna book off the record and you'll think about what you want to do right now?
Yeah, just for a minute.
Okay, we'll go off the record for a few minutes while I handle another matter.
Okay.
What's your name, sir?
Matthew Ross.
Okay. Do you have an attorney?
I do not.
Okay, I'm gonna put you in a private meeting room with Mr. Joseph, who's the plaintiff's attorney, okay?
Okay.
Thank you, Judge.
No problem.
Judge, do you want me just to go back to breakout room 2?
That's correct.
Okay.
Judge, Miss Reed and I settled our matter for 2:30 and sent in a CD to your courtroom email.
Correct. I already signed that one.
Okay, great. Just wanted to confirm. Thank you.
No problem. Thank you.
No, what the hell is this?
Hey, to work. Love you.
You should be in the meeting now. Tap your screen. Tap it.
Tap it.
You have mute.
Mr. Joseph, are you there, sir? Mr. Joseph? Ms. Storball, are you there? You're muted, ma'am.
Sorry about that. I'm here.
Which matter are you?
I'm here. I'm sorry.
Storball, which matter are you?
I am here for Evans and Hahn with Mill Pond.
Oh. Mr. Joseph, were you able to come to a resolution with Mr. Ross?
Yes,
And what type of resolution is that, sir?
consent judgment for possession.
Okay. I'll let Judge Simmons know. Thank you.
Thank you.
Ms. Reed, are you there, ma'am?
Yep. How are you?
I'm good. Were you able to come to a resolution with Miss Evans?
Not yet. If while we're waiting for the judge, if you want to throw us in a breakout room, we can see where we're at.
Sure.
If you might put Miss Doorbell in there as well, I'd appreciate it.
Sure.
Thank you.
Okay. Mr. Joseph with. Mr. Joseph, can you hear us? Mr. Ross and Mr. Joseph? Okay, Ms. Honig, are you all set? You can come up. Mr. McKay's been waiting for some time, so let's get that one taken care of. Back on the record in the matter of Michigan State Housing versus Elsa Honig. Ms. Honig, I've given you an opportunity to kind of digest what you're going through and figure out how you want to move forward today, if you want to enter into consent judgment at all, or if you wanted to proceed with the hearing or make any other motions for the court at this time.
I can't continue with the hearing today. My lawyer's unavailable. And I really don't want to agree to be gone by the 22nd. So I don't know if I can ask for a continuance.
Okay,
Or one more.
You
or-
are going to hire an attorney to appear here? Is that a yes? I have to pick it up on this?
Yes. Yeah.
Okay, and this is the attorney that you've been counseling with?
Yes.
Why didn't you have your attorney appear today?
I wasn't able to get in touch with her. I left a message for her this morning and I just called and she's out of the office for the rest of the day. We did think, when I was consulting with her originally, Judge, we thought this was not
Okay,
such a,
because I don't want to get into any
I know.
protected conversations you've had with
Right.
your attorney.
Right.
I'm going to stop you. But what I am going to do is we're going to give you one last adjournment. You need to bring your attorney, okay?
Yes.
March 29th. March 29th at 3:15.
Okay.
If your attorney, she's gonna need to file, he or she is gonna need to file an appearance.
Okay.
And if that date and time doesn't work, they need to notify the court immediately. So that we can get another date that works for you and the plaintiff, okay?
Okay.
Well, March 29th, Your Honor, that's the soonest we got for hearing date.
That We're doing far better than some of the other courts in this courthouse. I can tell you, the judge across the hall is into May already.
Well, you can take it under advisement, but I have to ask for if there's going to be any further adjournments, and perhaps an escrow would be in order.
I did indicate that this will be her last adjournment. That's based on the fact that she's indicated that she's been receiving some counsel and she wants to have her attorney appear. But you can make a motion for escrow and file it with the court, and I'll review it.
Yes, Your Honor. Have a good day, Your Honor.
Thank you. We're off the record. We'll get you a copy of your notice to appear. You're welcome. I don't see Mr. Joseph or Mr. Ross. Daniel Evans. She's back there. Ms. Reed, did you meet with Ms. Evans already?
Yes, we did, Your Honor. Thank you.
Okay, I think Mr. Bigelow is gonna go and bring her in here.
I
Mr. Joseph, are you there? I'm not sure where Mr. Joseph went, Mr. Ross. And what's your name, sir?
We're here on the RKD versus Roberts matter. Charles Gazillo on behalf of RKD.
Okay, thank you. Okay, Ms. Evans, you can come up.
Okay.
We're on the record in the matter of FR Lansing LLC versus Danielle Evans. This is file number 22-03223 LT. Appearance for the record, counsel.
Thank you. Sarah Reed appearing on behalf of the plaintiff.
Thank you. And we have Ms. Evans present in the courtroom, and she's without counsel today. Like you and Ms. Reed met privately, correct?
Correct.
Ms. Reed, did you all come to an agreement?
Well, it is kind of an odd situation, Your Honor. It's my understanding when Ms. Evans filed her motion back in, I guess I'm not sure if it was January or February, but when we were here about 3 weeks ago, her balance was at that time about $2,900. It's my understanding, and anybody can correct me if I'm wrong, that she indicated she's been approved for $870 through DHHS. But as Your Honor knows, they usually require the tenant to make their payment, or I call it a copay, but that's not really what it is, first, which was $2,100, and then they'd pay their $870, which would have brought her current. My client hasn't received any notification regarding that approval. But then also in the meantime, March rent is due today. So that payment presumably would bring her current through February, but now that we're into March, that presents another issue. So it's just kind of an odd situation because of the motion, the timing, and the copay, and now we're into another month.
Okay. I see she's got some paperwork with her. But ma'am, is what she's saying accurate? You were approved for some funding?
Yes.
Okay, through DHS?
Yes.
What amount?
$870.
Okay.
And my co-payment was, like she said, almost $2,100.
Okay. And you've not made that payment?
Well, I showed them the verification. I have it right here.
Okay. What is that? The actual payment that you're going to make?
Yes.
Okay. Is your plan, you're prepared to make that payment today?
Well, I went to the office to make the payment. They don't take partial payments.
Gotcha.
So it's just a matter of my caseworker releasing the funds.
Okay.
Then I got the 500 that's in escrow.
Okay,
and then I have rent
for March.
Yes.
Okay. So Mr. Reed, do you think adjourning this will allow an opportunity for these payments to catch up. I don't know how the sequence is gonna have to go for the DHS payment, though. That I can't work out for you, but she does seem to have a, looks like, is that a money order or a check?
It's a cashier's
She
check.
has a, it appears to have a cashier's check from Lake Trust for her copay, or whatever the payment that she needs to make, and so she just needs her caseworker to get that other amount, and FR Lansing won't take a partial payment or won't take her payment unless they have the entire payment in full. Is that correct?
That's my understanding. That's correct, Your Honor.
Okay. Well, then, ma'am, are you able to get in touch with your caseworker to let them know you have the check that you need, or for your portion that they need to send their portion? So
Yeah, I've been trying to get in contact with them about it. I've even filed a hearing
with their caseworker at DHS.
Yes.
Have you spoken to our eviction diversion facilitator?
Yeah. Honestly, he wasn't much help.
Mr. Russell couldn't help you make contact? Okay.
You mean he could help me get in contact with my caseworker?
Well, he could assist or try to assist. If you're saying that you've
Oh.
already gotten approved and you're just trying to make contact with someone.
I have the decision notice right here.
Okay, we can see if he can provide that assistance. I mean, that's what he's here for.
Okay.
And so I'm gonna give you a new court date. When you leave here, you should go down to the 5th floor and meet with him.
Okay.
And see if he can help connect you, because what you're trying to do is make sure you can align the time frame that they're gonna get that check over, so you can get a payment in full to FR Lansing.
Right.
Before this next court date, preferably, so that Ms. Reed can come in and dismiss the case if it's paid in full.
Okay. I have that. Yeah, it was, is that it right there?
March
Okay.
29th at 3:15. March 29th at 3:15.
Okay, March 29th. at 3:15.
Okay, and is there any objection to what I just suggested, Ms. Reed?
Just for the record, Your Honor, just on behalf of my client, they would object to any further adjournments, but obviously that's the court's discretion to allow further adjournments on this matter.
Okay, sounds good. I'll note the objection, and it's reset for the March 29th date to allow all these payments to coincide so that she can be paid up, so she has the amount in full. Any
Very well, and that was-
additional matters today?
I'm sorry.
Sorry?
Is that 3:15, Your Honor?
That is at 3:15 on March 29th, correct?
All right, thank you very much.
You got your notice to appear, ma'am?
Yes, ma'am.
Okay, go down to see Mr. Rosa when you leave here, okay?
Okay, thank you.
Thank you. Who's on the Motorola Moto G Power?
That would be me, Scott Roberts.
That's who you're here for, sir?
That is correct.
Okay. Do you have a device that you can get on Zoom with? Maybe you all can try to meet privately and see if you can come to an agreement?
I
Do you have a device?
no, I only have my phone right now.
No, well, now I'm not talking to you, you're already on Zoom. Oh, we can get you on our device, okay?
Oh, perfect. If I may, Your Honor, real briefly.
You may.
Mr. Roberts is in the process of moving now. So I'm thinking the only issue will be money damages.
Okay, well, you can talk to him and see if you all can come to an agreement, maybe a consent judgment. If not, we can address it on the record. Who's on the Samsung SM? Ma'am, can you unmute and tell me your name? You're still muted.
Angela Ralston.
Thank you. Scott Roberts, we're gonna put you in room 1. Mr. Joseph, can you hear me? You might be in another courtroom.
Judge, are you calling for Huron Development?
Yeah, I was calling for you because I wanted to go on the record on Mr. Ross.
Yeah, we have a consent. We can place on the record.
Okay. We're on the record in the matter of Edward Rose Associates versus Matthew Ross, file number 22-03516 LTE. Appearance for the record.
Joe Joseph for the plaintiff.
And Mr. Ross was present. Mr. Ross, are you still there?
I am.
Okay. He's without counsel. You have both met privately and you have a consent judgment. Can you put the terms on the record?
Yes, Judge. Consent judgment for possession only, $6,556.80. That's due. Cost of $166.56. Total amount $6,723.36 with a writ to issue after the 13th. And Mr. Ross has consented to his name being signed to the judgment and has been given his rights under 4.201 as well.
Okay, Mr. Ross, can you start your video, please?
I'm sorry, what was that?
I need you to start your video.
I'm sorry.
Okay, so Mr. Ross, is it true that you have entered into a consent judgment to pay the amount of $6,723.36 on or before March 13th or vacate by that date?
Yes, ma'am.
Okay, and you understand, sir, that you have the right to be represented by counsel today?
Yes, ma'am.
Are you giving up your right to be represented by counsel in order to enter into this consent judgment?
I am.
You also have the right to proceed to a hearing, or you could have demanded a jury trial in this matter. Are you giving up the right to have a hearing in this matter so that you can enter into consent judgment?
Yes, ma'am.
Anybody forcing you or promising you anything in order to give up your rights?
No, ma'am.
Okay, you have 3 business days to return to the court. If when you leave here, you determine that you misunderstood any of the rights that you're waiving in order to enter into consent judgment, you can request to have the judgment set aside. You'd have to articulate to the court how it was that you misunderstood your rights, okay?
Okay.
Are you giving Mr. Joseph consent to sign your name on this consent judgment?
Yes, I am.
Okay, do you have any questions today?
No, I do not.
Okay, you're all set then. Thank you.
Yeah, thank you.
Thank you, Judge.
Mr. Joseph. See, Robert Colbert. What about Carrie Hahn? Okay, Ms. Reed, you can submit the defaults on both those.
All right, very well. Email them over this afternoon. Thank you very much.
Thank you. Ralston is present. I don't see. Oh, no. Joseph Cooper.
Good afternoon, Your Honor.
Good afternoon. We have Angela Ralston here. She's without counsel today. That's correct, Ms. Ralston? You have to unmute, ma'am.
Yes.
Okay, Mr. Cooper, did you want me to put you in a private meeting room so you all can discuss this matter?
No, Your Honor. According to my client, the parties have agreed to a consent judgment we'd like to put on the record if we could.
Okay, very good. We're on the record in the matter of Sam Rental LLC versus Angela Ralston, file number 22-03762 LT. Appearance for the record.
Joseph Cooper on behalf of Sam Rental LLC.
Thank you. And we again have Ms. Ralston via Zoom without representation. Mr. Cooper, can you please state the terms of the consent judgment?
The possession judgment for the defendant to retain possession of the property, rent is $3,963, costs of $163.86 for a total of $4,126.86 to be paid on or before March 21st, 2023. And the plaintiff can apply for an order evicting the defendant if the defendant does not pay on or before March 21st, 2023. Then I apologize, Your Honor, this is a little bit unusual for me, but it seems that they'd also agreed to terms of a money judgment for $2,763 with damages, costs of $163.86 for a total of $2,926.86.
What's the total money judgment again?
$2,926.86.
Okay, very good. Okay, Ms. Ralston, is what Mr. Cooper saying accurate about the agreement you're seeking to enter into?
Yes.
Okay, so you've entered a consent judgment, or you're willing to enter into a consent judgment for possession, and you're willing to pay the amount of $4,126.86 on or before March 21st, 2023, or vacate by that date, correct?
Yes.
Okay, you're also entering to consent judgment as to a money judgment in the amount owing of $2,926.86, correct?
Yes.
Are you, you have the right, ma'am, to be represented by counsel during these eviction proceedings, and you're giving up your right to be represented by counsel in order to enter into this agreement, ma'am?
Yes.
Okay, you also have the right to proceed to hearing, which was scheduled for today. You could have demanded a jury trial in this matter as well. Are you giving up your right to have hearing in this matter so that you can enter into consent judgment?
Yes.
Anybody threatening you or making any promises to you to get you to waive your rights and enter into judgment?
No.
Okay, you have 3 business days from today's date to return to the court. If once you leave here, you determine that you misunderstood the rights that you're waiving in order to enter into this agreement, you can request to have the judgment set aside, okay?
Okay.
You'd have to articulate to the court how it was that you misunderstood your rights. Do you have any questions today, Ms. Ralston?
No.
Okay, are you giving Mr. Cooper permission to sign the consent judgment on your behalf?
Yes.
Okay. Any additional matters for the record today, Mr. Cooper?
No, ma'am.
Okay, you're all set, Ms. Ralston. Thank you, Mr. Cooper.
Thank you, Your Honor.
Mr. Whitty's client,
It's here.
Big
It's a
15.
dismissal. I gave him a dismissal.
Oh, okay, sorry. Okay, we're on the record in the matter of RKD Investments LLC versus Scott Roberts and all others, file number 22-03786 LTE. Council appearance, please.
Thank you, Your Honor. Charles Gazelle on behalf of RKD Investments, whose member Don Thomas is seated to my left.
Thank you. And then Mr. Roberts is present via Zoom. He is proceeding today without counsel. You indicated before going on the record that you believe he is or is in the process of vacating the property. This is an eviction or termination of tenancy matter. And it sounds like you all have entered into consent judgment.
That is correct, Your Honor.
Okay. Okay, so the judgment here Mr. Roberts, by consent indicates that you're gonna vacate the property on or before March 8th, 2023. Is that correct, sir?
Yes, ma'am.
Okay, there's also a consent as to money judgment or damages owed in the amount of $6,081.50. Says you owe damages in the amount of $5,950 plus cost of $131.05. You're consenting to money judgment in that amount, sir?
Yes, ma'am.
Okay, in order to enter into this consent judgment, you have to give up a couple of rights. One of them was the right to be represented by counsel. You were advised of those rights back on your pretrial in February, and you've appeared today without an attorney. You're waiving your right to have counsel in this matter, sir.
Yes, ma'am.
You also have the right to proceed to a trial on this matter. You could have demanded a jury trial, or you could have had a hearing which was set for today. Are you waiving your right to have a hearing in this matter or proceed to trial?
Yes, ma'am.
Okay, anybody threatening you to get you to waive those rights?
No, ma'am.
Was there any promises being made to you in exchange for you waiving those rights?
No, ma'am.
Okay, you have 3 business days, sir, in order to return to the court. If you leave here and you realize you misunderstood any of the rights that you're waiving to enter into this judgment, you can request to have this judgment set aside, okay?
Okay.
Lastly, would you grant permission for us to sign your name to this consent judgment?
Yes, ma'am.
Do you have any questions today, sir?
No, ma'am. I pretty much understand what's going on.
Okay. Any additional matters for the record today, counsel?
No, Your Honor.
All right, you're all set, Mr. Roberts. Thank you.
Thank you, Your Honor.
Okay. Thank you.
What you said was gonna be is it a conditional dismissal? Regular